Okay, welcome to this particular session, and we are talking about biodiversity and land use from a comparative perspective. We have 3 speakers instead of 4 speakers, which is giving us extra time for discussion and questions. And we will be hearing 3 different experience or examples from New Zealand, China, and Australia. My name is Shaukat Alam. I'm the panel moderator for this, and the way it will work today is each presenter will have 20 minutes time for presentation, followed by questions and discussions. So our presenters are Trevor Dyer Winterbottom, who is the Associate Dean Research at University of Waikato. We'll be talking about sustainable management, sustainable ethic from New Zealand perspective. Second presenter is Miao He from Ghent University, talking about sustainable development through a rights-based approach to conserve protected areas in China. And final speaker is Jacqueline Williams, and although it's a co-authored paper with Amanda Kennedy and Donna Craig, but Jacqueline will be presenting on their behalf. And Jacqueline is from University of New England, talking about threatened species in Australia. So may I welcome Trevor Dyer Winterbottom to actually start this presentation.
Kia ora, kia ora tātou katoa. Greetings from Aotearoa, New Zealand. What I'm going to talk about over the next few minutes is sustainability from a New Zealand context. In terms of overview, New Zealand is an ancient country geologically. It's rich in biodiversity, with approximately 80,000 species, mainly birds, amphibians, reptiles, and fish, very few mammals. It's a country rich in natural resources and steeped in indigenous Maori culture and values. It's also a country that legislated for sustainability in 1991, preferring the legislative route rather than a policy route. But despite the rhetoric of sustainability, New Zealand's environmental law and governance continue to grapple with a range of issues that one could describe as being persistent challenges. There are, however, some new developments that are emerging that may assist in promoting sustainability and environmental justice, and we'll look at those in terms of our journey. In terms of sustainability, it's useful to go back in time and also to look widely at some of the thinking in relation to this concept. One of the particular papers that I picked up through the course of researching for this paper was one by a former IUCN Director General, Dr. Martin Holgate, in his 1995 paper, How Can Development Be Sustainable?, where he said this: sustainable development is a synonym for rational development because it's a process of making the best practicable use of natural resources for the welfare of people. Some quite interesting remarks there or in that quote. Firstly, in terms of it being a process for making the best practicable use of resources, and secondly, linking that to the general concept of welfare, and that's certainly a concept that is firmly embedded in the New Zealand statutory scene. New Zealand enacted the Resource Management Act on the 1st of October 1991. It is our primary environmental statute out of a group of approximately 35 statutes that govern the natural and physical environment. New Zealand law is highly codified in statute. There is, to all practical purposes, no real common law in relation to the environment, apart from specific decisions of the courts interpreting and building upon statutory provisions. The Resource Management Act has at its core a purpose section, Section 5, which deals with sustainable management. It contains two meanings of sustainable management: a short definition, which is in Section 5, subsection 1, as quoted here on this slide, to promote the sustainable management of natural and physical resources, and then an extended definition in Section 5, subsection 2, which talks about enabling people and communities to provide for their social, economic, cultural, and health and general well-being, whilst safeguarding the rights of future generations, safeguarding the life-supporting capacity of land, air, other environmental media and ecosystems, and thirdly, avoiding, remedying or mitigating adverse effects on the environment. And in terms of the provisions of Section 5, particularly the extended definition, you'll pick up from there that there is a balancing between what might be seen as a liberal economic view in the preamble to Section 5.2 in terms of enabling people to provide for their needs and their welfare, whilst also seeking to safeguard intergenerational equity, ecosystems, and avoid adverse effects. Interestingly, when New Zealand was going through the debate on reforming and restating its principal laws relating to the environment, which took place during the period of 1988 through to 1991, and also went through a change, a political change in government from Labour to National. The concept of whether it should be sustainable development or sustainable management was contested both intellectually at an expert panel level and also more robustly through the parliamentary process, debates in the House of Representatives and in select committees. After the election of 1990, the then incoming national government commissioned an expert panel review of the then bill to work out whether, as a safe bill, it should be passed. And as we can see, one of the specific matters that was looked at in that report was the advantages and disadvantages of using sustainable management as opposed to sustainable management. And we can see there from the quote on the slide that committee was firmly of the view that there were aspects of sustainable development which, in the view of the committee, were unlikely to be justiciable in a statutory context, or be capable of being interpreted by the New Zealand Environment Court. After enactment of the statute, there was a debate, particularly between the period 1994 and 1997, as to the meaning of sustainable management. Largely, it was a debate in ministerial speeches and in academic law journal articles. A debate between the then Minister for the Environment, the Honourable Simon Upton, and various legal, philosophical and geographic academics. One of the strong themes that was emphasised by the Minister was the liberal enabling function in Section 5.2, and an approach particularly to land use, which was one of non-regulation, and in terms of land use, The statute proceeds on the basis that a consent is not required for land use unless the particular land use would offend against a rule that's been promulgated in a district plan by a territorial authority. We can, however, see that there's a degree of tension in terms of the new statute, or this statute as it now is 20 years old, in terms of that philosophy and what actually the statute implies in terms of its structure and architecture. A fundamental difficulty being identified between the neoliberal ideological underpinning of the statute and the fact that implementing the statute would paradoxically require more rather than less intervention and more rather than less planning to give effect to the statute. One of the reasons why the statute might require more rather than less planning to give effect to it is the nature of the drafting of the statute. It's a framework statute. If you want to work out how sustainable management is actually going to be translated to affect development or to protect natural areas or to safeguard against contamination of resources, then that needs to be implemented through a hierarchy of other instruments, whether they be national policy statements, regional policy statements, regional plans, or district plans. In terms of New Zealand's record of implementing sustainable management as opposed to sustainable development, at the Rio Plus 10 mark, we had experienced by then 10 or 11 years of the Resource Management Act and had the phenomena of by then having no national policy instruments promulgated by central government to guide local authorities in terms of how to prepare their plans. We also had have a situation under the Act where, apart from preparing a coastal plan, regional councils are under no obligation to prepare any other kind of plan. Interestingly, when the Resource Management Law Reform project was launched in December 1988, the comprehensive consultation document that was prepared at that stage envisaged that regional plans would only need to be prepared when there was an issue, a specific issue, like, for example, issues in relation to scarcity of water that might need to be addressed. Obviously, no one was thinking of the time period that might be required to prepare a plan and take it through the statutory process, which in New Zealand takes approximately 7 years in terms of going through that part. Justice Peter Salmon is of interest in the New Zealand context for two reasons. One, he was the first environmental lawyer to become Queen's Counsel, and subsequently he was the first environmental lawyer to sit on a High Court and then the Court of Appeal bench. And it was in that context that Justice Salmon attended the Judges Forum at Johannesburg and came back and presented the first in a series of lectures that are still given annually in his honour. What he did there was to emphasise that we do need a guiding ethic to influence how we develop and influence and interpret environmental law in New Zealand. And there Justice Salmon picked up on the concept of justice and indicated that whether we're thinking of sustainable management or sustainable development, we should seek to embrace that and use that as a guiding ethic in terms of how law and policy are developed. Also, hand in hand with that, he identified a number of specific challenges, particularly in relation to the availability and scarcity or potential future scarcity in 2002 of fresh water through various competing uses for water bodies and water sources, and also in relation to water quality. Most of you will be aware that New Zealand is a agricultural country with a large dairy industry. It's also a country that produces approximately 70% of its electricity from water, river water through hydro dams. So there is a large competition in terms of access to and use of water between dairy and electricity. And in terms of the areas best suited for electricity generation from water and dairy, they tend to be the same 2 or 3 regions in the country where water use is highly competitive. One of the other issues picked up by Justice Salmon was the question of Indigenous rights and having an ability for Maori engagement in the resource management process. In terms of the Act, there have been a number of issues that have continued to be issues of debate, both in 91, 2002 and today. To pick out 3, we currently do not have a national policy statement in force in relation to the protection of biodiversity on private land. As a result, there is a highly politicised debate that goes on via the preparation of district plans through their submission and hearing process, where landowners put forward quite strenuously property rights-based arguments against regulation. There's a preference for voluntary methods to be used, and not unsurprisingly, the amount of native forest cover on private land continues to decline, and we see continued threat to habitat. We also see threat to habitat under other aspects of New Zealand environmental law, such as the Crown Minerals Act in relation to mining. One example of that will be on the west coast of the South Island, Stockton mine, where that mine was granted a permit to extend into an area which resulted in an ecological site of approximately 3 acres in extent being entirely destroyed. It was the sole habitat of a small population species of indigenous giant land snails, meat-eating snails. Snails are very well, but they don't live where they used to live, and they've been unable to be translocated back into any other environment. But if you speak to the scientists at the Department of Conservation, they'll tell you that the snails are very happy in the fridge. In terms of clean water, the competition for water on our longest river, the Waikato River, is extremely intense. There was a hearing on that last year before the Environment Court, where the debate was in relation to whether the water available for allocation could be increased by 1.4% of the 1 in 5 low flow. And that was competition between dairy and hydro. The court increased the flow by 1.4%, and within 2 weeks of the court's decision, more applications have been filed to take up that additional 1.4% than is available in the 1.4%. And those applications are currently now being processed and litigated. Maori recognition of interests is again a matter that has been of persistent debate, but as we'll see, it's something that has been looked at. In terms of new strategies to deal with those issues, we have had now a number of national policy statements that have come forward. We've got some regional rules to deal with some matters. We do have co-management, but we're not making much traction with biodiversity. In terms of national policy statements, We now have two that are relevant to the issue of water resources, one on renewable electricity generation, which underscores the emphasis on renewables in the New Zealand context, looking both at using hydro, wind and geothermal. Because of issues in relation to landscape protection, wind energy is not being advanced very quickly. Hydro, there are now very few opportunities. The growth area in renewable electricity generation presently is in relation to geothermal exploration. There are some wave energy schemes, one of which has been through the Environment Court and being consented on the largest natural harbour in the country, the Kaipara Harbour, but that's subject to a 10-year exploratory regime where they gradually put a number of turbines down through monitoring. But it will be 10 years before they work out whether the full scheme can be implemented. The National Policy Statement on Fresh Water seeks to tackle two issues. One, to encourage regional councils to prepare plans for water allocation, and also to encourage regional councils to prepare plans to deal with water quality. And in terms of water quality, we're dealing primarily with nitrogen discharges from agriculture into rivers and lakes. Interestingly, the draft National Policy Statement on Indigenous Biodiversity, whilst not unsurprisingly taking a preference for non-regulatory methods, departed from the way the previous policy statements had been promulgated by central government, and although it was open for submission, the Minister decided to dispense entirely with any public hearing on those submissions. In terms of freshwater allocation, in the Waikato River region, the Waikato Regional Council has promoted a variation to its regional plan to deal with water allocation. That was the case that went through the court last year. A real competition during that hearing for various uses of the river in terms of water for stock and shed for dairy, water for pasture irrigation, water for irrigation for horticulture, municipal supply, and water for use in relation to electricity generation, whether it be water in terms of hydro or water for use for cooling for thermal plants. On the Waikato River, there are a series of 7 hydro dams. We're responsible for producing 40% of water from hydro, and also the country's largest thermal station. In terms of nitrogen offsetting, the headwater of the Waikato River is Lake Taupo, the largest lake in the centre of the island. There has been a real issue with nitrogen discharges, and again the Regional Council has prepared a discharge plan just dealing with that particular catchment, essentially a cap and trade nitrogen discharge system. People can swap their nitrogen discharge allowances with each other, or if you're wanting to be an entrant, then you need to buy them from somebody who's already got them, seeking to achieve a 20% reduction through a public fund. $81 million has been set aside by the Regional Council and central government to buy up rights. And we see here that in terms of dealing with those transfers have to go through the consenting regime under the Resource Management Act. Coming to Maori Indigenous issues, we have a grievance system under the Treaty of Waitangi Act 1975, which allows Indigenous rights to be litigated. They were litigated in terms of the river. There are strong connections between Maori and particular water resources, which hold special cultural and spiritual significance. So not unsurprisingly, given those strong connections, that issue was litigated. It resulted in a Treaty Settlement Act, specific statute dealing with that. Two things came out of that statute, one being a provision for a vision and strategy which takes effect as part of the regional policy statement. It's contained in the statute. The Regional Council had no option but to incorporate that in its policy statement. And secondly, what came out of the settlement was specific provision for equal Maori and non-Maori membership on all local authority committees dealing with resource consent or resource use decision making, whether that be at plan stage or consenting stage or in relation to enforcement matters. In terms of that settlement issue, this was quite a radical departure from anything that had been done in New Zealand before. All of our previous treaty settlements had focused simply on rights of participation in debates. So in conclusion, we have still an ongoing debate in New Zealand. Arguably, after 20 years of sustainable management, we are still not grappling with substantive issues in any real way. Lack of national guidance has been a problem. The Act itself, in its 20 years, has been amended 17 times. There is currently ongoing at present the 18th reform programme currently being debated. There is an opportunity to resolve some of these issues, lay some of these ghosts to rest, but arguably there will be further policy failure in this cycle. Thank you. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Thank you so much. Our next presenter is Miao from Ghent University, and she'll be talking about sustainable development through a rights-based approach to protected areas in China.
Ladies and gentlemen, good afternoon. My name is Miao He. I come from the Department of Public International Law, Ghent University, Belgium, where I conduct my PhD research under the supervision of Professor Anne. I'm grateful for this valuable opportunity to give my presentation. My topic is Sustainable Development through a Right-Based Approach to Conserve Protected Area in China. Before my presentation, let's look at the overview. The first part is the background information. The second part is existing legal and policy instruments in China. Third part is why RBA is a bad method. The first part, how to adopt RBA to conserve protected area in China. Finally, the conclusion will be made. According to the Economical Ecosystem Biodiversity Study, we know that protected area has large economical benefits. However, the main goal is to achieve the double win between protected area conservation and human rights protection. Protected area in China with total surface of more than 1.5 million square kilometers, which play a very important role in the world. On this slide, you can see that it offers economical promise such as Yunnan, Tibet, Xinjiang province that contain the best nature area for biodiversity. Important decisions are usually driven by economical social interest, rather than by the strategic objective. Consequently, the conflicts between protected area conservation and human rights protection exist in China. The conflict has become the biggest challenge in conservation activity. Let's look at 2 examples of conflicts in China. When the collected forest of Yuhu village are incorporated into Yunlong-Xueshan protected area in the northwest of China, without full involvement and meaningful construction, the farmers respond to cutting down the trees they have preciously managed. Another example is Binzhou Marine Nature Reserve. The local enterprise owner appealed to the National People's Congress to ask a more open and transparent designation to safeguarding the interest of local people. Actually, the main reason for this conflict is that the related parties do not have enough rights to voice their opinion in the decision making. So the question arises, what channel of the representative could guarantee or at least help local people to influence the decision making? The model of legal existing system for protected area in China is on this slide. The basic target of conserving protected area in China is not only to conserve ecosystem and biodiversity, but also to promote the economic development of surrounding areas. Chinese government and different departments have issued various laws concerning environmental protection for protected area, but they do not contain too much reference to the human rights. As for the right to information, the first two regulations has pointed out the related information openness for the principle. Article 13 from the Nature Reserve Land Management approach has pointed out that it should have a clear indication and announcement to the public to know what the boundary for the protected areas. However, this no clear article from any law or regulation has pointed out the right to information concerning environmental issues. Regarding to the right to public participation, there are some limitations. The organization form is single. For instance, the environmental NGO have limited impact in the decision making. The process for public participation are many post-supervision. There are little pre-supervision or process supervision. The contents are many conscious participation. There are little participation in the real behavior. The guarantee for public participation is insufficient in China. As for the existing legal and policy instrument referring to right to participation, the Constitution provides some guidelines for the public participation. Then the Chinese agenda and another regulation point out it should involve the public participation, but they do not give a clear explanation about it. Fortunately, some improvements have been made since 2010. For instance, the notification on further strengthen the hydropower construction for environmental protection point out when constructing hydropower must guarantee the public right to participation and right to information. Some improvements also being made by the provincial governments. For instance, the suggestion on Hubei Xindongsan Nature Reserve Management regulation aims to protect people's right to information and right to participation. The improvements need to be further developed for solving the conflicts between between protected area conservation and human rights protection, not only on paper, but also in practice. Based on what I have discussed, it obvious that to find a better method to better balance protected area conservation and human rights protection become urgent in China. A right-based approach meets this need. A right-based approach to conservation was first adopted at the IUCN World Park Congress in 2003 and strengthened the World Conservation Congress in 2008. RPA to conservation is an innovative approach to adjust policy and instrument to better balance nature conservation and human's right. There are some important added value for a right-based approach to conservation. First, it clarifies rights and duties. Not all the related parties know what they should do and what they can enjoy. That is the main task in the legislation in China in the next stage. The second added value it is meet increasing demand from NGOs. That is, it should better balance the nature of conservation and human rights protection. IBA can stimulate the potential role for NGO in the conservation activities. IBA to conservation also play a special attention to the most vulnerable people, for instance, indigenous people. As you might know, China has the largest group of indigenous people in Asia. It is necessary to pay a special attention to their interests. IBA links the international, regional, and domestic interests together to form the earliest basis for international cooperation. Last but not least, it is a holistic approach to analyzing the positive and negative impact of conservation activity on people's rights, as well as the impact, the enjoyment or lack of enjoyment of people's rights on conservation efforts. Finally, to achieve the sustainable development. IBA is not a policy, it's only a back method. Changing from outside. Not all governments have fully engaged in the long-term conservation goals or human rights protection. Fortunately, Chinese government have recognized this issue and made some progress on this problem. However, China still needs to learn the related experience from another country to solve the conflicts. Challenging from global and regional human rights tests, that is, global and or regional human rights tests are mainly about human rights. They contain few references to the environmental issues. That is also a big challenge for a developing country like China, who want to solve the conflicts according to the international or regional principle and the legal instrument. Challenging inherent to IBA itself, the competition between rights. Within one group or across several groups, there will be a competition between rights. For instance, how can the indigenous people's rights be balanced with the rights of future generations? IBA also requires the substantial resources of time, expertise, information, and funding to build capacity. Obviously, it is a big challenge in China with a rapid economic development, an enormous environmental resources consumption, and a huge number of population. It cannot expect China to solve the conflicts in one day. We are trying our best step by step. That is the overview for how to implementing IBA for protected area in China. Specifically, step 1, empowering rights in legislation of protected area. Analyzing the related party to find out who is or are the most vulnerable people. And one of the key points of empowering rights in legislation in China is to how to divide power and interest for the related party. There are 2 points need to be mentioned. First, to establish a accessibility system for the local governments and related parties. Second, to provide a dynamic management for the different protected area. The local governments may change the policy according to the different protected area or according to the different period for protected area construction. Step 2, safeguarding the rights in the enforcement of legislation on protected area. Provide information to the related party, especially for the vulnerable people, and ensuring all the related parties' participation, and stimulating the enthusiasm of the related party, shifting the legal passive conservation on protected area to the initiative protection, especially for the local residents. Step 3, assessing rights when evaluating the enforcement. When safeguarding the rights in the enforcement on protected area, it is necessary to assess the baseline indicators contents to ensure which rights are being protected for vulnerable peoples and the schedule of natural resources. As for the Chinese situation, with a huge number of population and per capita land resources is very limited. It's a big challenging of conservation and development for protected area. The baseline and the indicators for assessing the rights when evaluating the enforcement will be different depending on the different region. Step 4, providing legal remedy. If the implementation does not go well, the legal remedy will be very useful. Besides the economic compensation, the job training, benefit sharing can be another kind of compensation. Persecution while violation amounts to agreeing when it is necessary. Last but not least, after the first NGO for environmental protection has established in 1978 in China, more than 3,000 of NGOs have played a very important role in the conservation activity. When this first step has been implemented, they might have to solve the conflicts in China. Actually, this part will be my research in the next stage. So now are only the general and the principal issue to implement RBA in China. Finally, I would like to just 4 points as a conclusion. First, China has made some progress in solving the conflicts, but some problems still exist. An RBA can contribute to meet the needs of Chinese contemporary situation. How to specifically implement RBA in China is the further research. To achieve the sustainable development between protected area and human rights needs the efforts from various aspects. Our final goal is to achieve the sustainable development, not only in China, but also all over the world. Thank you for your time and attention.
Thank you so much. Our next speaker is Dr. Jacqueline Williams from University of New England, Australia.
Everyone awake? Okay, I'm going to speak about threatened species law in Australia. And just to give you an overview of what I'm going to cover, so I'm going to have a look at the evolution of environmental law in Australia, and then the threatened species legislation and how, I guess, how Rio 1992 sort of influenced that. And then look at the context and background of look at biodiversity and land use conflicts, and looking at mining and a threatened species, which is the giant barred frog, which is on the red list of the IUCN. And then I'll just look at new policy initiatives in Australia, so the COAG reform, which is the Council of Australian Government Reforms, and strategic land use in New South Wales, and recommendations for law and governance reforms. So just as an overview, looking at how environmental law has evolved in Australia, it's really been quite responsive to issues ever since, I guess, the early 1800s. If you have a look from 1803, as tree clearing was banned in Hawkesbury in New South Wales. But there's been sort of criticism about how environmental laws evolved in Australia because of its being responsive to issues, and it hasn't necessarily had a logical framework compared to other areas of law. And while sustainability has sort of been enshrined in a lot of our legislation since 1992, it hasn't been effective in getting any environmental outcomes. So just looking at, I guess I'm going to explore some of that through this threatened species law in our country, and using a threatened species example of how our law isn't actually achieving the outcomes that we desire. So just from this diagram, you can see that Agenda 21 UN 1992 actually influenced where some of our legislation has come from. So we have our National Strategy for Ecological Sustainable Development, Intergovernmental Agreement on the Environment, and the National Strategy for the Conservation of Australia's Biological Diversity. The government's translated those policies, if you like, into legislation. So that's where our sustainability is actually enshrined in there. So we've got two levels of legislation. Is one on the Commonwealth level, which is dealing with matters of national environmental significance, so that's the Environmental Protection and Biodiversity Conservation Act, which I'll call the EPBC, which is easier to say. And the other one, which I'm using, New South Wales Threatened Species Conservation Act, because that's where this particular threatened species is located. So I'm just trying to draw that we have a federal level of threatened species legislation and a state piece of legislation. They have common elements. So we've got listings, we've got critical habitat, ecological communities, we've got key threatening processes, we've got recovery plans, we've got triggers, referrals, assessments, actions, threat abatement plans, and scientific committees. And I guess that's where I wanted to start, where I called the beginning of lost in translation starts, because we have these different jurisdictions and then all of a sudden it starts getting messy. For example, the listing criteria and categories applied by the Australian and New South Wales government are both based on the IUCN standards. However, some legislative requirements and differences in the scientific approaches of the New South Wales Scientific Committee and the Threatened Species Scientific Committee, which is the federal level, lead to significant differences in listing focus, particularly to ecological communities. So we need a nationally consistent approach to scientific assessment and listing processes. We also have a bilateral agreement in place that was established in about 2007, where even though we have this federal piece of legislation that says the minister must decide on matters of national environmental significance, the bilateral can push it back to the state. So just to give you an overview of how our biodiversity in this country is actually faring, our latest State of the Environment report came out late last year, and it's saying despite promising investment by all jurisdictions, the decline of biodiversity is continuing. And that's virtually the same on the New South Wales level as well. After 15 years of having Threatened Species Conservation Act, biodiversity is still declining. And a recent paper found that populations of 72% of nationally threatened terrestrial species in our country are in decline. So there's an issue of, we have these pieces of legislation, they have got sustainability enshrined, they're not actually giving us any outcomes. So I guess I just want to use as an example, because in Australia at the moment, as probably elsewhere, but we're particularly going through this new conflict of mining in significant areas, coming to agricultural lands, I guess, more, and impacting other biodiverse areas that haven't had that sort of impact before. And this just gives you an overview. This is the Advanced Minerals and Energy Projects just for April 2011. So trying to, what was it, 1.28, oh no, not that one, $173 billion worth of estimated capital expenditure. So that was just gives you an overview of what the sort of activity that's happening in our country and the sort of boom that's coming up. So there's lots of areas that are under I guess, pressure for land use conflict, and that's where I'll introduce the case study that I'm going to explore how dysfunctional our threatened species law is in Australia. So on the left is a giant barred frog, which I took that photo because I did the field work as well, so it's quite interesting because I live near that mine site, so I'm involved on a community level as well as a researcher. So this frog is listed internationally, listed nationally, listed on the state as threatened species. The scientific committee says it's in danger of becoming extinct within the next 10 or 20 years if we don't look after its habitat. Its main habitat is Wild Cattle Creek. So that's where its habitat is, and that area in particular is has a huge antimony deposit in that area, and the price has gone from $4,000 to $16,000 a tonne in the last 2 years. So all of a sudden we have all of these mining companies doing exploration, working out how much money they can make out of antimony. What occurs with antimony is usually gold as well, so they're looking for both of those things. So I'll just give you an overview of how they're listed on the federal level and on the state level. and what is actually happening on the ground as far as how these acts are translated into practice. So on the federal level, broad threats have been identified for this frog. The threat abatement is project related only, so they don't actually have a threat abatement plan. Community groups have to apply for money through competitive government grant programs to try and abate the threat. And I think there's about $150,000 that's been given in the last 5 or 10 years. So that's on the federal level. There's only recovery plans for South East Queensland, which is another state, and it's got a much smaller population there. No critical habitats being identified, and there's only survey guidelines. So if you want to survey the frogs, there's a national approach to doing that. On the state level, on the New South Wales level, the threats are broad and unclear. The threat abatement's unclear. There's no critical habitat identified, and recovery plans again for another stage. I guess that I'll go through what the EPBC identify as threats when you consider that there's a mine or exploration mine activity actually happening in their critical habitat. So upstream clearing, changes in water flow regime, degradation of water quality, disturbance to riparian vegetation, feral animals, domestic stock, weed invasion, they're the main threats. So we'll go to Wild Cattle Creek, and this is in practice. So this is how our laws have been translated in practice. So the exploration licence activities that are occurring on that site, they were approved without an environmental impact assessment. Under the Mining Act, they were supposed to have a thing called a referral of environmental factors, which is equivalent to a lesser EIA. For some reason, even though this site is renowned as critical habitat for an endangered species, that didn't happen. There's been disputes with the landholder, and that landholder has had to go to arbitration with the mining company. And there's been breaches of the exploration licence, so some of the drilling happened outside the access agreement area, and there's also been some significant degradation and unauthorised use of water. So what's really interesting about this is that there was no trigger of either of the acts at all. So the community actually identified that and wrote to the federal government and the state government and asked them, you know, would they refer this? Because under the Act, that the Minister can ask the mining company to refer itself, or both the Commonwealth agencies and New South Wales agencies can refer the matter to be reviewed under the EPBC if it was a controlled action or if it was a breach. And what was responded was that it's normally the responsibility of the proponent to refer themselves. So it's up to the mining company to refer themselves if they think they might have to be considered for a breach, or that they actually are undertaking a controlled action. So the legislation clearly says what the Minister can do and what the Commonwealth and the state agencies do, but they don't actually do it. There has been, so that's a community referral, EPBC, that didn't happen. There has been a fine. The Mining Act under the Mining Act there's been a fine of $2,500, which is not a lot, but they did breach the rehabilitation guidelines. The other thing that's been followed up at the moment, because there was significant clearing of native vegetation and removal of soil and dumping into creeks, which is actually habitat, that community is following up on whether other pieces of legislation have been breached. So, just go through. Yeah, so I'm just trying to demonstrate what it says what happens in practice and what it says in the law is two entirely different things. So I guess as an overview of what are some of the issues with threatened species law is inconsistencies in scientific assessment and listing processes. It lacks that jurisdictional communication and coordination. So we've got federal and state that aren't coordinating at all, and in fact making it more opportunistic for people to actually break the law. There's inconsistency in offsetting and biobanking. And the objects of the Act need to be operationalised through clarity of ESD. So this is a typical example. Critical Habitat Register is underutilised. We have critical habitat registers on the federal level and state level. I think we've got four sites in New South Wales on the Critical Habitat Register and 5 nationally. So that's all. And there's a reason apparently why Critical Habitat Register isn't being utilised, but it's not that clear. And there's also clarity required in interaction with planning legislation, so triggers and strength. And that came about with the Mining Act as well. Does the Mining Act override the threatened species legislation on a state level? And I guess that brings us to the whole government-mining relationship that we're faced with in Australia at the moment, and the issue of vested interests, and where we have an issue with our federated system that the states have the vested, they have the interest in the natural resources, and so they get the royalties from the mining activities. So the states aren't mandated to have a national interest and matters of national significance, and it's not really their role. So I guess that's a big issue when we're trying to deal with, okay, the states are supposed to look after threatened species and the environment as well as they get the royalties. So there's that sort of issue of we need that oversight of the federal government to ensure that the environment's actually catered for. So I'll just cover some new policy initiatives in Australia because they do relate, and that's the COAG, which is the Council of Australian Governments. Just recently, a couple of months ago, they announced their major reforms of environmental laws, which really significantly is the EPBC Act. So the main things that came out of that reform is that there's accelerated accreditation of state processes, fast tracking of approval of major developments in each state, rationalising, removing energy efficiency and climate change schemes in each state, and removing other environmental laws seen as unnecessary and costly for business. So I guess I'll just briefly cover the issues with some of those COAG reforms, because that's going to take away that oversight I was talking about with the vested interest in the states away, so that we won't have the Commonwealth having that assessing those matters of national environmental significance. They're actually going to be devolved to the states. And there was a review of the EPBC Act by Hawke, and he proposed a reform package to streamline development balanced by better environmental provisions and increased transparency, oversight and public participation. What's happened is the government has sort of cherry-picked some of those reforms and left a lot of the other balancing checks and balances out. So we've actually ended up with a fast-track removal of red tape that benefits business, not necessarily the environment. The other policy initiative I want to cover is something in New South Wales that was an election platform to deal with this issue of agricultural land and mining conflict. So this is a strategic regional land use policy. So and it's aimed to ideally protect high value agricultural lands, biodiversity lands and water resources from mining and coal seam gas. The basis of them are their 5-year regional plans, and they map strategic agricultural lands, biodiversity, minerals, coal seam gas, cultural heritage and priority offset landscapes. They have a gateway process, so there's an independent experts assess the mining and coal seam gas proposals against criteria, and it does not pass this stage. If it doesn't pass the gateway stage, it can't go to the development application process. But the plan also, even though it's supposed to protect agricultural land, it's supposed to also create some certainty for mining industry. And the issues with this new policy is that it actually fails to protect high value agricultural land. So in the regional plans, there's no areas that are prohibitive from mining. There's been questions about the independence of the Gateway Panel, and I guess it's something that I don't think it's quite been set up yet, so it's still wait and see how it works, and it's really quite unknown what the criteria for assessment will be. And it doesn't apply to all mining and coal seam gas activities, so those areas that are mapped as high value agricultural land, which are questionable in the criteria that was used, it's only if it's within 2 kilometres of that, or within that it triggers the gateway process. The biodiversity data and the mapping is incomplete, and it really relies heavily on biodiversity offsetting. So rather than protecting those biodiversity areas, it's promoting offsetting those to other areas. There's no specific actions for comprehensive assessment of cumulative impacts. There's exceptional circumstances where there's something of state significance, a huge resource, then it can just override the gateway and it can go to Cabinet and they can approve it anyway. And it does lack engagement with Indigenous communities on cultural heritage. So I guess just as an example of, threatened species law is what is wrong with environmental law in general in our country. And most of this is from Justice Preston, the judge from the Land and Environment Court in New South Wales, who's done an excellent paper on this. But I won't read these out, but these are some of the aspects that we need to consider as what's wrong with environmental law. And the sort of reforms we need, which we've heard today already, that we need a nature-centred approach away from the commodity approach. We need to operationalise sustainability. We've heard about what is sustainability, but how do we actually get those outcomes? And also social justice for communities. So there's two things I sort of identified, and I won't read all of these, but one is the legislative reform, so how we actually write the acts and how we get that, how do we operationalise sustainability from a particular piece of legislation is one thing, and there's a number of points there, but it does need good governance backing that up, adequate resourcing, open standing and access to justice. But the other aspect that seems to me that's a big issue is the institutional reforms. And in our country you can see where the jurisdictional issues actually create an environment where development is actually fast-tracked and the environment is not necessarily looked after. And that's why I think the lost in translation, and we have to be careful when we intend to operationalise sustainability and the actual outcomes. What does harmonisation really mean? What does streamlining mean? What does consistency and equivalence and red tape? And what, I guess, we need to be really careful in what we end up with. Like in Australia now, there's comments saying that we're actually winding back the 20 years that we've just gained in environmental law by the COAG reforms, because they've chose to harmonise, streamline, create consistency and red tape for business outcomes and not necessarily the environment. I think that's me. Thank you.
Thank you so much. Thank you. Now we have some time for questions, comments, or discussions. If you could come over the speakers and then. Okay, now I'm open for questions. If you could introduce yourself first before asking the question.
Okay, I'm Lynn Harmon from Pace Law School. I have a question for Jackie. What is the role of nonprofit organizations in litigating decisions like this in Australia, if any?
What I know, and I'm involved with that community organisation as well, is that there's little room in the EPBC unless you know otherwise. It's just there's little opportunity other than to try and hold everyone else account to who should be following that up. So it's more taking on the government who have the role, the government agencies who have the role, who should be following up on those particular issues. So,
I would just add, not only is there little room, there's also a lack of funding as well for these organisations to pursue that litigation. So the role tends to become, as Jackie's alluded to, more of championing the relevant points in government to take on what is their legislated role to start investigating.
Yeah, there is the Environmental Defender's Office, and I know they're looking at this particular case to see if there is room to, first they act on behalf of the community groups and write to the different ministers and the agencies, but they may take it on. There's little room in the EPBC to actually have any standing anyway, which is, we're back to what's not within the acts, creates that situation where there isn't any standing.
Do you have any cases where citizen groups can sue the government or sue developers in order to stop environmentally destructive processes? I know that sounds very confusing. Coming from the United States, where that's really common, I just wondered if that's...
Even in this case, so that the landholder has huge degradation issues from the mining company who undertook exploration licence activities and breached it. And she had to follow it up. She had to virtually get to ABC to do a story on it, and then shame them into turning up and having a look, and then it's only $2,500, which is not, and then they still have to come back and rehabilitate the site. So it's not really. I'm not aware of any.
The only related stuff would be Paul might be able to add more on this, like the Karuna Coal Action Group litigation but that was more, not so much about degradation, but the mining approval process and whether that was valid. So more preemptive before the actual degradation.
One of the things that goes with increasing efficiency in most countries is the transfer of power to administrative authorities to be determinative. And a large part of what's happened here is the creation of determinative power by administrative authorities. So yes, you can take admin law action if you've got the resources, but you also have to prove that they have violated their administrative discretion, and it's very broad. So
yeah.
it's a difficult problem.
Same in the US. It's true. Yeah.
Yes.
Hi, I'm Elizabeth Kirk from the School of Law. I've got two questions. First of all, one for Miao. I really enjoyed your presentation, but I wanted to ask you about something that you didn't actually talk about. In one of your early slides, you had a picture of all of the reserve areas in China, and you had national reserves, provincial level, and city level reserves. I was particularly interested to see that there are city level reserves. And I wondered if you could say something about the sorts of sorts of environments that are preserved within these reserves. What's covered by them?
I'm sorry?
You have these different levels of reserves,
yeah.
And I was particularly interested in the city level reserves.
Mm-hmm.
So I wondered what was incorporated within those reserves, what type of environment is being preserved. And is it areas where you also have perhaps people engaging in industrial activities or agricultural activities? So I wondered if you could say something about the nature of the land.
I can give an example. Is that in Shenzhen City, the land for protected area in Shenzhen is about 8% of total area. The Shenzhen governments have give a very kind of example to all country. That is the governments provide several job training and benefit sharing for indigenous people and take care of them, and the protected area conservation goes very well. And on the other hand, the life quality of indigenous people have got enough conversation for their future life. Yeah, that is a good example from Shenzhen City.
Okay.
Yeah, thank you.
Thank you. And if I may, I had a question for Trevor as well. I'm very interested in the point you made about the wave power and the length of time it seems to be taking to get authorization for the wave power projects to be implemented or finally fully given permission and authorization. I was really surprised by the apparent length of time that it's taking, because I know that within the UK we've had only really one wave power plant authorised, but it didn't take anything like as long as it seems to be going to take in New Zealand. And I wonder if you could explain why the process is so lengthy.
The consents that have been given in the Kaipara Harbour to a company called Crest Energy is the first wave energy scheme in New Zealand to be consented and goes with the Environment Court. Kaipara Harbour is the largest natural harbour in the country. They are putting turbines down in pairs, primarily because they're concerned in terms of the effect of the scheme on Benthwick and other communities in the harbour, and also in relation to the fishery in the harbour. Sorry. They wanted to take it in a slow staged way. The company itself was satisfied with the decision that came out from the court, and there was no further appeal beyond the Environment Court to the High Court. So, in terms of its economic viability, the project must be viable. It is being implemented. The first two turbines are there, and the monitoring is being carried out. So there is no other benchmark to assess that one against. It's possible that the next scheme that comes along won't be subject to the same level of scrutiny because there'll be that baseline monitoring in place.
So is it more of a tidal power system that's in place then? When you say the turbines are being put in place, are they, from what you said, it sounds like they are beneath the sea level rather than on top of the sea level?
That's correct.
Reflecting on the papers inside, and well, to hear all of yours, Trevor, but it seems to me that we've got something that's occurring with law where we're stating, in effect, fairly broad principles. We think they're specific, but principles about the priorities for the environment in various forms, or the ways we'll deal with that, in the case of Jackie's paper, or consultation being a required process, etc. But because we're not able to specify the circumstances and the processes well enough, there's an enormous amount of variation and sometimes abuse that's going on, which is a real problem. With all of your papers, if we wanted to make implementation work, what would we have to change in the law? Or is it just the case that we're going to have to stumble through and try and deal with by litigation, for example?
In a New Zealand context, the answer is relatively simple.
Can you speak a bit louder?
In a New Zealand context, the answer is relatively simple. The plan-making process at regional level needs to be compulsory, and there needs to be a full suite of plans to regulate all aspects of environmental media.
And with China, with the consultative and community processes and a rights-based approach, what needs to happen there?
I think that China, as a developing country, we can't solve all the conflicts in one day, just like a developing country. As we might know that the World Bank has given us a model for the relationship between economic development and the environmental quality. That is the the development country has already from its the lowest level to the high level, but China is still struggling for how do you say? Is still struggling from the want to get rid of the lowest level. Yeah. So there was the difference.
And with the biodiversity law, Jackie?
Well, I mean, someone brought it up today, that burden of proof. I mean, where should that lie? Because that would change. I mean, what we're seeing, say, with the mining rollout is that communities are actually having to get legal and scientific expertise and harness so many resources and then take on court cases and all that sort of stuff. If you just change the burden of proof, then that might change the ball game quite significantly.
Any more questions? All right, would you please join me in thanking them for this.